let's start with the easy part and define affirmative action. Affirmative action is a government or private program designed to redress historic injustices against specific groups by making special efforts to provide members of these groups with access to educational and employment opportunities. I like this definition because it also explains why affirmative action exists: to redress historic injustices, which means discrimination. The key aspect of affirmative action is that it provides special access to opportunities, usually in education and employment, to members of groups that have been discriminated against. Now, where affirmative action gets controversial is when you look at the two ideas of access and opportunity. When you poll Americans, they generally favor equality of opportunity, although they usually don't like it when the government tries to promote equality of outcomes, usually by redistributing wealth. But I'm getting ahead of myself. This means that Americans generally think that other Americans should have an equal shot at success, even though they don't imagine that all Americans will be equally successful. Not all of us can be Donald Trump, although not all of us want to be. Since we tend to believe in the USA that education and jobs are the keys to success, equality of opportunity is tied up in access to these two things, and that's why they are the focus of affirmative action efforts. Here's where it gets tricky. In order to increase access to education and job opportunities for members of groups that are historically discriminated against, affirmative action programs try to ensure that they get extra special access to jobs and schools, which to many people is not equality of opportunity. Legal types often will use the metaphor of a thumb on the scale to describe the added benefits that affirmative action programs supposedly provide. But we could also see it as a head start in a foot race, which is the metaphor I prefer, for reasons I'll explain in a bit. But first, let's go to the thought bubble. So, while affirmative action started with LBJ ordering government agencies to pursue policies that increased the employment of minorities in their own ranks and in soliciting contracts, the first time it made a splash at the Supreme Court was over the issue of university education. Specifically, in the landmark case of Regents of the University of California versus Bakke in 1973, the court ruled on the issue of racial set-asides, or quotas, in admissions at the University of California Davis Medical School. Of the 100 slots available to incoming med students, 16 were set aside for racial minorities. Bakke claimed that this meant that some people who were less qualified than he was, at least he felt so, got into Davis Med School and Bakke didn't. So he sued, claiming that the quotas discriminated against him because he was white. The Supreme Court ruled in Bakke's favor, saying that racial quotas were not allowed since they didn't provide equal opportunity. But they also ruled that affirmative action programs were allowed if they served a compelling government interest and were narrowly tailored to meet that interest. In other words, if they passed the test of strict scrutiny. One of the more interesting things about this decision is the kind of stuff the court said constitutes a compelling government interest. They rejected the idea that righting historical wrongs was something that the government should undertake, probably because it opens up all kinds of historical cans of worms, especially the question of who decides when and if a historical wrong has been redressed. What they did say was a compelling government interest was ensuring diversity in university admissions. This is true in general, and as long as we can imagine there being universities, the state has an interest in seeing that their classes represent diverse viewpoints. Diversity benefits both the members of the minority and majority groups, at least in the minds of the courts. Thanks, Thought Bubble. This is just a pretty serious video. I don't know when I was going to get that eagle punch in, so I just did it there. The early 1970s were the high tide of affirmative action in the US, and ever since then the courts have looked less favorably on affirmative action claims. Because they apply strict scrutiny, most affirmative action claims are struck down. This was clarified in the case of Adirondack Constructors Inc. versus Pena in 1995, which dealt with racial preferences in the hiring of subcontractors on government projects. Although this case meant that the government was not supposed to give preferential treatment to minority-owned businesses or those that employed a large number of minorities, a government report from 2005 found that, at least as far as the federal agencies were concerned, the practice was still widespread. In most of the cases it hears, the court has struck down affirmative action provisions because they fail one or another of the strict scrutiny tests. But the basic idea that universities can create programs to build and maintain a diverse student body has been upheld. Two relatively recent cases involving the University of Michigan show how complicated it can be. In the 2003 case of Gratz versus Bollinger, the court ruled that Michigan's undergraduate admissions policy, which awarded extra points to people in racial minority groups, was unconstitutional because it was not narrowly tailored to meeting the goal of student body diversity. In the same year, in the case of Grutter versus Bollinger, Bollinger just keeps showing up at the Supreme Court because he was the president of the University of Michigan at the time. Lucky. The court ruled that the admissions policy of Michigan's law school was narrowly tailored to meet the goal of promoting diversity, although it said that in 25 years such a program might not be necessary. So, at the time we're making this episode, the idea that universities can take race into account in their admissions so that they can create a diverse learning environment for their students is still constitutional. But the Supreme Court looks very carefully at the actual policy that the university has in place, and if it looks anything like a quota, they'll strike it down. It turns out there was another place to punch the eagle. 2 times. Affirmative action remains controversial, and it looks like eventually it's going to disappear, but maybe not right away. In 1996, Californians passed a ballot initiative, Proposition 209, that effectively outlawed affirmative action in public employment, public contracting, and public education, especially university admissions. After this initiative, also known as the California Civil Rights Initiative, passed over vocal and organized opposition, the graduation rate among African Americans in some California universities went up. On the other hand, the enrollment rate of African Americans at many UC schools declined, and it only returned returned to 1996 levels in 2010. Other states like Michigan have passed laws similar to California's Proposition 209, making it harder and harder for affirmative action programs to flourish. But as is often the case in politics, people's response to affirmative action differs depending on how you ask the question. When phrased as an anti-discrimination measure, ballot measures like Prop 209 are quite popular. But when people are asked if they want to get rid of affirmative action, their responses are not always so positive. Support for affirmative action remains, and I suspect that this is because many people still recognize that some form of support for minority groups is needed in the US. And this brings me back to the reason why we have affirmative action in the first place. While the courts have ruled that attempting to correct the historical injustices of slavery and Jim Crow laws are not a compelling enough interest to justify affirmative action, for many, they are. Minority groups, and in particular African Americans, have suffered from horrible treatment and legal disability from the time they began arriving as slaves in 1619.
Affirmative action is back in the news, and this time, Harvard is getting sued. Now, usually these types of lawsuits make the claim that when race is considered in college admissions, white people are unfairly discriminated against. But this lawsuit is claiming Asian Americans are the ones being hurt by these policies. Plot twist. So while this lawsuit against Harvard has a new angle, it really does boil down to an age-old debate over affirmative action. Should race be a factor in college admissions? Okay, so when it comes to college admissions, affirmative action refers to policies where race and gender are considered in the application process. Now, they're not the only thing that colleges are looking at. They're still looking at your grades, your SAT scores, extracurricular activities, all that good stuff. But they also take into account your race and gender in an effort to help ensure that women and minorities are getting equal access to higher education. The idea was born out of the civil rights movement in the 1960s, as a way to help counter the long-standing racist and sexist barriers that kept minorities and women out of elite universities. Barriers like, I don't know, the fact that women couldn't get a degree from Harvard until 1963, or the idea that people of color weren't as smart as white people. The 60s were messed up, man. We needed rules to help. Some see affirmative action as kind of like a counterbalance to legacy admission policies, which is when applicants get preferential treatment if someone in their family attended the school, a perk that tends to benefit wealthy white applicants, since they were the only ones getting into these elite schools in the first place. And to be clear, affirmative action isn't always about race. It's definitely helped a lot of white women, but now that co-ed is kind of the norm, the controversy is almost always over race. And over the years, there's been a stream of lawsuits challenging it, mostly from people who feel they've been unfairly rejected because of race. The most recent being this Harvard case. So let's take a look at both sides of the argument. Those in favor of affirmative action see it as a way to fight long-standing discrimination when it comes to educational opportunities. They think it's necessary in making sure that minorities with good academic standing have access to higher education. And there is some data to support this. 8 states have essentially banned affirmative action practices, and instead have what's known as race-blind admission policies. So, the New York Times looked at admissions data from public universities in a bunch of those states, and they found that when schools got rid of affirmative action, there was a dip in Black and Latino students, even as their populations grew. But it wasn't true for every university and state. In fact, Florida has actually done a pretty good job of keeping its enrollment of Black and Latino students at pace with the population, despite getting rid of affirmative action. Yep, you heard me right. That was Florida, the same Florida that brings you headlines like these. Affirmative action advocates also point out that a more diverse campus benefits everyone, not just the students it's specifically designed to help. With the diverse student body, all students learn valuable interpersonal skills outside of the classroom, like how to interact and respect people that are different from you, skills that set you up for a successful life in a diverse world. Now, that doesn't mean that being nice to people of color is gonna get you a lot of money, but who knows? And then once you get into the real world, there's evidence that diverse teams make better decisions and are actually even more profitable to businesses. So maybe I was wrong. But if you're on the other side of this argument, you don't see affirmative action that way. Many opponents believe that affirmative action policies are themselves discriminatory and can actually create racial tension. They say that qualified candidates end up getting rejected from schools while less qualified minority applicants get accepted for the sake of diversity. They even have a term for this, reverse discrimination. And at elite schools, less qualified could be the difference between perfect SAT scores and getting one question wrong. And this discrimination is kind of what the Harvard lawsuit is all about. The plaintiffs are essentially claiming that Harvard is holding Asian Americans to a higher standard because they don't want too many getting in compared to other groups. And, the argument goes, this can hurt race relations. If people are assuming that minority students are only at a school because they got special treatment, then those students might not be seen as equals in the eyes of their professors and their peers, even if they would have gotten in without affirmative action. And that doesn't exactly create an environment of inclusiveness. Some opponents say that instead of being race-based, affirmative action should be class-based. That way, a student of a single white mom from Appalachia or a low-income Asian immigrant family would get a leg up. Then you're not actively hurting poor whites or Asians. And of course, there are other opponents that think even that's too far and just want college admissions to be based on merit, like looking at your test scores and your GPA. There's also the argument that affirmative action isn't even really working. According to another New York Times analysis, admissions of Black and Latino students is still lacking at many top universities. And instead of focusing efforts on affirmative action policies, some opponents think that we should tackle the problems that both low-income and students of color face early in the education system. Problems like lack of resources or advanced courses. That way, we set students up for success from the beginning.
We begin tonight with the Supreme Court striking down affirmative action and reshaping college admissions. In a 6-3 decision, the justices ruled that Harvard University and the University of North Carolina violated the Constitution by considering race when deciding whether to admit someone to their school. A landmark case overturning nearly 50 years of precedent. The latest example of the conservative majority redefining American law, including abortion rights and guns. The ruling means higher education institutions will need to come up with new ways to create diverse student bodies. Groups of protesters, mostly made up of young adults, gathered outside the court to voice their outrage. And to underscore how monumental this case is, 6 of the 9 justices wrote opinions, many personal and strongly worded. CBS's Major Garrett has all the new details and will start us off tonight from outside the Supreme Court. Good evening, Major.
Good evening, Nora. Yes, it was personal, with justices on the touchstone issue of race talking to and past one another. This sweeping and historic ruling effectively ends affirmative action in college admissions, reversing decades of precedent that less conservative court majorities had protected and giving colleges and universities some latitude to consider race as one factor as they sought to build more diverse student bodies. Writing for the majority, Chief Justice John Roberts said admission policies at Harvard University and the University of North Carolina violated the 14th Amendment's Equal Protection Clause. The student must be treated based on his or her experiences as an individual, not on the basis of race, Roberts wrote. Many universities have for too long done just the opposite. In a scathing dissent, Justice Sonia Sotomayor accused the court majority of ignoring history and precedent. The court cements a superficial rule of colorblindness as a constitutional principle in an endemically segregated society where race has always mattered and continues to matter. At the White House, President Biden criticized the conservative majority.
This is not a normal court.
And said the nation must find a new way to achieve diversity in college admissions.
What I propose for consideration is a new standard, where colleges take into account the adversity a student has overcome when selecting among qualified applicants.
The opinion also exposed deep personal and ideological divisions within the court. Justice Ketanji Brown Jackson, the first black woman to serve on the High Court, wrote in her dissent, quote, "With let them eat cake obliviousness, the majority pulls the ripcord and announces color blindness for all by legal fiat." Clarence Thomas, the court's other black justice, responded, quote, "Justice Jackson uses her broad observations about statistical relationships between race and select measures of health, wealth, and well-being to label all blacks as victims."
We won't go back!
Outside the court, students and civil rights leaders assembled to protest.
I think in this moment in time, it's important for every institution, from colleges to corporations, to commit to pledge to diversity no matter what.
Ed Bloom, the president of Students for Fair Admissions, brought the case to the court, arguing race should not factor into admissions decisions at all.
Ending racial preferences in college admissions is an outcome that the vast majority of all Americans, of all races, will celebrate.
CBS News polling shows that 70% of Americans think race should not be allowed as a factor in college admissions. But statistics indicate that in states that have banned affirmative action, such as California and Michigan, admissions for Black and Latino students have fallen dramatically at their most selective universities. Shruti Kumar, a student at Harvard, opposes today's court ruling.
I think the idea that our society can be colorblind is a silly one. We don't live in a perfect meritocracy.
The decision was praised by most Republican primary contenders, chief among them former President Trump, who took credit for appointing 3 of the justices in today's conservative majority. Former First Lady Michelle Obama said she had benefited greatly from affirmative action and vowed to continue her work to build more minority inclusion in higher education.
All right, so have you heard of Edward Blum? Maybe the name isn't ringing a bell, but I'm sure you're familiar with some of his work. Despite not being a lawyer, Blum has been behind some of the most high-profile Supreme Court cases of the last decade, including what seems like his one-man mission to end affirmative action in the United States as we know it. In fact, in 2016, Blum was one of the forces behind Fisher versus University of Texas at Austin. That case concerned a white student named Abigail Fisher, who sued the university, arguing the school shouldn't use admissions policies that favor Black and Hispanic applicants over white students. Now, that case didn't exactly pan out as Fisher and Blum had hoped. In a 4-3 decision, the Supreme Court upheld the use of race in the school's admissions process. After that defeat, Blum is now back for rounds 2 and 3. In fact, last week, the Supreme Court announced that it would take up 2 affirmative action cases next term, this time against Harvard and the University of North Carolina. The lawsuits accused the 2 schools of discriminating against Asian Americans and, in UNC's case, white students as well. The plaintiffs claimed the school put them at a disadvantage and valued Black and Latino students more highly. Except here's the thing. The lead plaintiff in both the Harvard and the UNC cases isn't actually a student at all. It's Edward Blum. Now you might ask, what does Blum have to gain from meddling in the admissions process of schools he has nothing to do with? And why is he putting the Asian community at the center of this fight? Especially when you consider that Blum's organization, Students for Fair Admissions, has failed to present a single Asian American student at trial, and that 70% of Asian Americans are actually in favor of affirmative action. In fact, during Blum's previous attempt at knocking down the policy in Fisher versus University of Texas at Austin, more than 160 Asian American and Pacific Islander groups filed amicus briefs in support of affirmative action.
For more than 50 years, colleges have taken different approaches towards admissions to make their campuses more diverse. Considering an applicant's race, generally called affirmative action, has long been standard at universities from UPenn to Harvard, but not anymore. The Supreme Court has ruled that no college in the US can consider an applicant's race in admissions. 9 states have already banned this practice. California did almost 25 years ago. just enough time for a detailed study on its consequences.
Once you have the data set in hand, there's an awful lot you can learn, honestly, pretty quickly, right? Basically what I'm doing is just differences in means. What happened to the kids after 98? What happened to the kids before 98? Just those comparisons tell you an awful lot about not just what happened in California, but I think what we can expect to happen across the country.
Here's how affirmative action changed college admissions and what the future of higher education might look like without it. Before affirmative action, selecting which of these student applicants would be accepted was fairly simple. Most colleges would essentially filter students. They'd set factors like a minimum GPA or a minimum test score, and voila, there's your pool of accepted students. Obviously, the more selective the school, the higher those standards were. But
a big part of both test scores and grades are pre-18 educational investment and, honestly, non-educational investment. The degree to which you had a stable household, the degree to which you had some notion of being able to focus on your work. The better a high school you go to, the better the test score you get. The better sort of access to resources outside of high school, like tutoring or other services, that you had access to before 18, the better you test.
It's clear if you break down SAT scores by the background of the student. Students from higher income households score higher. Same if you look at who grew up in a household with a parent with a graduate degree versus no degree. That also reflects in race, with Black and Hispanic students scoring lower than white and Asian students. So in the 1970s, when UC Berkeley's admissions really just looked at GPA and test scores, the student population was less than 5% Black and Hispanic.
Students who might have been really high ability just weren't able to get the kind of education that would lead them to the kind of high standardized tests that would get them into a school like Berkeley. These schools recognized that they needed some way of admitting those students, and so they started affirmative action policies to try to bring in students from sort of every part of, in this case, the state of California.
So in the 80s, they began considering race in their admissions decisions. It worked. By the 90s, they would chart students on a social diversity index. If you were low income and a minority and had moderate grades and test scores, you were in. If you were high income and white, you needed higher scores to get in. Some colleges, like the UC Davis School of Medicine, used quotas, utilizing a similar filtering system, but a few spots would be reserved for minority applicants. In the late 70s, a white student named Backy fell here. Not good enough to get in among other white applicants, but with higher test scores and GPA than the minority students who got in. He sued, claiming discrimination. It made it to the Supreme Court, he won, and was admitted. The court ruled that while the goal of achieving a diverse student body is sufficiently compelling to justify consideration of race in admissions decisions, specific quotas went too far. More than 24 Supreme Court cases have followed, including the landmark Grutter v. Bollinger in 2003, which upheld that race could be considered as part of a highly individualized, holistic review of each applicant's file. That's essentially how affirmative action has worked the last 20 years. Instead of just filtering a pool of applicants, most colleges look at each person individually. Like Harvard will look at SAT and GPA, but also things like extracurricular activities, essays, awards, life experiences, recommendations, leadership, and yes, race. But this is exactly what the Supreme Court has now struck down. In two separate cases against Harvard and the University of North Carolina, plaintiffs argued this holistic approach was just a cover for discrimination against white and Asian students. The Supreme Court agreed, ruling that eliminating racial discrimination means eliminating all of it. The student must be treated based on his or her experiences as an individual, not on the basis of race. Many universities have for too long done just the opposite, which means in this holistic review, race can no longer be considered.
To the degree that these universities want to maintain their current level of racial diversity, California has shown that that is infeasible, at least given the policies that California has tried to implement.
In the 90s, Californians voted for Proposition 209, which banned public universities from considering race. Zach Bleemer conducted a massive study in California, following students that applied before and after Prop 209. looking at where they eventually enrolled, graduated, and then at their wage statements.
So you can see, so long as they stay in the state of California, where they work and how much they earn all the way through 2020, 25 years almost after the affirmative action ban was implemented.
What he found was that Black and Hispanic enrollments at more selective schools, like Berkeley, dramatically fell when they couldn't include race in their admissions process. Moderately selective schools had almost no change, but enrollment at less selective schools actually rose. Because most Black and Hispanic students didn't not go to college, they just went to less esteemed ones.
You got this cascade effect of Black and Hispanic students, on average, enrolling at a university that's just a little bit less selective than the universities they used to have access to. Kids who used to go to Berkeley are now going to UC Davis. Kids who used to go to UC Davis are now going to UC Santa Cruz. What happened is pretty substantial negative ramifications for these students.
They became less likely to earn STEM degrees, less likely to go to graduate school. Those with the lowest GPA and test scores became less likely to even graduate. And overall, Black and Hispanic students earned less in their careers than those admitted before Prop 209.
One thing we've learned from affirmative action bans is that the kids who are admitted to more selective universities as a result of race-based affirmative action tend to receive greater value from those institutions in terms of the degree to which those institutions lead them to more successful jobs or more success generally in the labor market than the white or Asian students who tend to take their places after the end of affirmative action programs.
Bleemer has also studied the effects of what's called race-neutral admissions policies, which can include outreach and income-based admissions, as has Georgetown University. They both found the same result.
It seems like all of these race-neutral alternatives that universities can implement have a tendency toward increasing the diversity of campuses, but they don't get you anywhere close to the level of racial diversity that's provided by race-based affirmative action.
Harvard said if it were to not include race in their holistic review, Black and Hispanic enrollment will decline by almost half. Berkeley, even though it has made strides since Prop 209 to enroll more Hispanic students, the Black student population is still below where it was when it could consider race in admissions.
I think we'll see declines in Black and Hispanic enrollment, potentially in some cases quite severe declines in the next couple of years. And as a result, you're going to have this sort of downward shift, Black and Hispanic students enrolling at less selective schools than they had access to previously. There's no clear silver bullet for such universities just to maintain diversity as it is right now.
A new study out today shows how college admissions practices benefit the richest applicants. Opportunity Insights, a group of Harvard economists, analyzed data from 12 of the country's top colleges from 1999 to 2015. They found that among students with the same test scores, applicants with families in the top 1% of earners were 34% more likely to be accepted. Those from the top 0.1% were twice as likely to be accepted. And schools gave preference to legacies and student athletes, among others. Overall, 1 in 6 students at Ivy League schools had parents in the highest income bracket. Raj Chetty directs Opportunity Insights and co-authored the study, and he joins us now. So Raj, based on your research, how are elite institutions giving an admissions advantage to students who come from wealthy families?
Great to be here, Jeff. So what we're finding in this study, looking at detailed admissions data for many Ivy League and other highly selective colleges, is that there are 3 key factors that lead to higher admissions rates for kids from the very highest income families in America, families making more than about $600,000 a year. The first is legacy admissions. If your parents went to a given college, you have a 5 or 6-fold higher chance of getting into that college relative to somebody else with the exact same application credentials. Second, recruited athletes have a significant advantage in getting into these colleges, and they tend to come primarily from very high income families. And third, we find that non-academic credentials, think of things like extracurriculars or other activities, leadership traits outside the classroom, these credentials tend to be much stronger among kids from very high income families, and in particular, much stronger among kids who went to elite private high schools, which of course tend to be attended primarily by kids from very high income families. Together, those 3 things explain why kids from the highest income families are about 2 times as likely to get in as kids from middle class families.
There are certainly people who will hear this and think that being wealthy affords all sorts of advantages in life. It stands to reason that that would extend to college admissions. Why, in your view, should this research give people pause?
I think what's surprising to us about this study is not simply that there are more high-income kids than middle-class kids at these colleges. As you noted, we might expect that given that there's accumulation of advantages that kids from high-income families have, going to better schools, growing up in better neighborhoods, so forth and so on, over many, many years. What's, I think, critical that we're finding in this study is that's not enough to explain why you have 1 in 6 kids coming from the top 1% at our nation's top colleges. Even relative to all those benefits, if you look at their SAT scores at the point that they're applying to college, something like 7% of kids with the highest SAT scores are coming from families in the top 1%. But 16% of kids attending our nation's top private colleges are coming from families in the top 1%. So what that's telling us is even above and beyond the advantages they've had throughout childhood, the kids from high-income families are getting an additional boost in the admissions process at the best colleges.
Our team reached out to some of the elite universities mentioned in your study, and a spokesperson from Princeton University says that this data is from 2015 and that the share of low-income students has changed since then. Here's part of that statement. The percentage of Pell-eligible students at Princeton has more than doubled since the first of the cohort Chetty analyzed was admitted more than a decade ago. Lower-income students now make up more than a fifth of the student body at Princeton. What do you make of that? And is it a mistake to look at this data from 8 years ago as if it captures the current moment?
So that's a great point, and we look at how these things are changing over time as well. And Princeton, in particular, has been a leader in admitting and recruiting more kids from lower income families. But what we're finding in particular in this study is that it's sort of the middle class that's being squeezed, that's missing from these colleges. And in particular, if you look at admissions rates, they're the lowest from kids in what you might think of as upper middle income families, going to what you think of as good public schools, living in good neighborhoods. Those kids have the lowest chances of getting in, lower than those kids at the bottom end of the income distribution, and especially much lower than the kids from the very, very top of the income distribution, many of whom are going to private schools and so on. And so that piece of it, I think, still persists today to the present point, and I think is extremely important to think about at Princeton and many other colleges around the U.S.
So if it's the kids from affluent families that are getting the advantages, and kids from the lower income families, in some cases, that are getting the attention from these schools that are focused on diversity, how should these universities make sure that their student bodies reflect economic diversity and include more middle-class families, as you mentioned?
I think it comes back to thinking about the 3 factors we identified as driving the very high income admissions advantage. Does it make sense to have legacy preferences? Does it make sense to be recruiting athletes in particular from the highest income families? And does it make sense to be focused on non-academic credentials? Now, one point I would stress in that context is when we follow these kids over time and look at their outcomes after college, you can ask, is it the case that kids with these stronger credentials, extracurriculars and so on, maybe they're more qualified candidates. Maybe they're doing better 10 years after college and it's sort of merited that they're admitted at higher rates. But actually, we find when we look at a wide variety of outcomes, your incomes, your chances of working at a prestigious firm, going to a top graduate school, there actually is no evidence that the kids who are getting those admissions advantages are doing any better. And so one simple answer to your question is revisiting whether those 3 advantages really make sense, possibly pulling back on them, could allow more middle-class kids a shot at these opportunities. Another possibility is to take a need affirmative approach and recognize that kids coming from less well-resourced schools, maybe they deserve a boost up in the admissions process as well.
Raj Chetty is professor of economics at Harvard University. Thanks for being with us.
Thank you, Jeff. My pleasure.
In the college admissions process, I feel like I had essentially every privilege possible.
I was thinking, well, Harvard is kind of my top choice. It's not guaranteed that I'm gonna get in, but this little bump because my father went there will put me over the edge.
It's painful for me to think that all of my hard work in high school was so irrelevant compared to the fact that I was able to check the box that my dad went there.
Legacy admissions is affirmative action for the rich. I mean, objectively, it's affirmative action for the rich.
It never really was a decision to apply to Harvard. It was kind of like, well, of course that's where I would go. Of course that's where I want to be. Once you get in, they tell you,
you belong here.
You belong here.
You belong at Harvard.
Harvard Admissions Council, they do not make mistakes.
We did not make a single mistake.
Every single one of you has earned your spot to be at Yale.
And chose you.
Because you are the smartest, because you're the brightest.
You were selected from almost 45,000 applicants.
You are the best, I guess, that America has to offer. And that's not really the case.
I applied to like 15 schools and got into 2 or 3 of them. It's pretty telling that one of those places that I got into was the place that gave me an explicit leg up.
I think for a long time, I really grappled with guilt and self-esteem issues related to me attending Brown, because there was always going to be that voice in my head that was telling me, it's because you're a legacy student, it's because you're a legacy student.
I didn't want to be reduced to just, he's a legacy admit. It's like telling the world I don't deserve to be here. I'm a fraud.
I think there is a pretty natural human shame in admitting that you might not have earned something.
From birth, I've been given so many advantages. Both my parents are educated. They're doctors who went to Ivy League institutions.
I come from an affluent family that was able to send me to private school.
Before I got to campus, I was kind of filled with this tremendous sense of sadness. If not for these incredible strokes of luck, that befell me, where would I be?
Legacy students are overwhelmingly wealthy, and they are overwhelmingly privileged in many ways that already give them a huge leg up in the college admissions process.
I wouldn't have a problem if it weren't so hypocritical.
You have just arrived at a place that values difference.
We do not want everyone to be cut from the same cloth.
They say all of these things, like the things that we care most about are having a diverse campus.
A thriving, diverse intellectual community is essential to academic excellence and critical to shaping the next generation of leaders.
To create future generations of successful people in America. But, I actually lived with my dad's college roommate's son.
There's people who I would run into on campus and I would say, that last name sounds really familiar. I think that my dad knew your dad and they played lacrosse together.
A school like Harvard is a small world. Things like legacy admissions help those environments be more insular and more secluded from people who haven't been a part of them.
These practices of maintaining admissions within a bloodline or within a family were literally the way that white Protestant college graduates hoped to exclude Jewish applicants.
If you hear someone talking about limiting who can live in a neighborhood or have a certain job, it is discriminatory. For some reason in legacy admissions, we hold that up to be virtuous.
It's so easy to say now, oh, I wouldn't have checked that box.
Because I can't go back in time. I think now all I can do is speak up about legacy admissions.
I have a responsibility to call out the hypocrisy of legacy admissions more than anyone else because I benefited from it.
I cannot say clearly and with enough emphasis to my alma mater, please get rid of the considerations of legacy status in admissions.
Ending legacy admissions just feels like a layup for equality.
I would love for my kids to go to Brown, but more than that, I'd want my kids to see me speaking up against something that I feel is wrong.
It's as easy as removing the checkbox.
Get rid of it.
Legacy admissions has to go.
Children of the super rich are more than twice as likely to get into America's most elite universities as middle-class students with the exact same test scores. This fast-tracks them to become the next generation of CEOs and lawmakers and helps keep wealth and power in the hands of people who started out wealthy and powerful. A big reason rich kids have such an advantage is so-called legacy admissions, the preference elite schools give to family members of alumni. The vast majority of Americans across the political spectrum think this is unfair. An astounding 68% of all voters support banning legacy admissions outright. This is the strongest bipartisan agreement I think I've ever seen on an issue that boils down to who gets special privileges in America. Now, I went to an Ivy League school, Dartmouth, followed by Oxford and Yale Law. I wasn't rich. My father ran a clothing store. That was a half-century ago, before inequalities of income and wealth exploded in America, before the middle class began shrinking, before the American oligarchy began corrupting American politics with a flood of big money donations. Today, it's much harder for a middle-class kid to get the same opportunities that I had. New research conducted at Harvard, ironically, looked at 16 years of admissions data from the Ivy League schools, plus Stanford, Duke, MIT, and the University of Chicago. The research reveals that 1 in 6 students at these prestigious schools comes from the richest 1% of American families. Why are so many rich kids getting in? It's not because they're better students. Children from the top 1% were 34% more likely to be admitted than middle-class students with the same SAT or ACT scores. Those from the top 0.1% were more than twice as likely to get in. Legacy admissions are one of the biggest reasons. Nearly 30% of Harvard's class of 2023 were legacies. It's a vicious cycle that consolidates wealth and power in the hands of a few. Less than 1% of Americans get into one of these top schools, but their graduates account for 12% of the Fortune 500 CEOs, a quarter of all U.S. senators, and more than a third of all Americans with a net worth of over $100 million. And because these graduates are in the winner's circle, their children have every advantage in the world, even before they get legacy preferences into the same prestigious universities, which in turn hand them even more advantages. You see how this entrenches an American aristocracy? Concentrated wealth at the top leads to even more and more wealth concentration with each new generation. It also perpetuates racial discrimination. Since non-white students were barred from most colleges for most of American history, legacy students are by definition more likely to be white. The Ivy League's legacy policies were introduced during the Jim Crow era, with the specific intent of limiting the number of students of color and Jewish students who could be admitted. To this day, about 70% of Harvard's legacy admissions are white, which is why the U.S. Department of Education is now investigating Harvard for potential violation of civil rights. And with the Supreme Court's ruling against affirmative action, this systemic racism is likely to get worse. The court is pretending to make college admissions race-blind while preserving systems that advance wealthy white students over all others. It's time for the government to ban legacy admissions.
So corporate diversity, equity, and inclusion programs are coming under fire now as conservative groups are pushing against the workplace policies.
Legal threats against companies promoting these initiatives have only ramped up since the Supreme Court ruling that determined affirmative action was unconstitutional. So Lauren Weber is joining us now here in Studio 57. She's a reporter for the Wall Street Journal who recently co-wrote the piece titled "The Legal Assault on Corporate Diversity Efforts Has Begun." And, you know, we talked about the affirmative action case that had to do with college admissions, but a lot of these cases, too, were sort of have been bubbling around in the lower courts. It so happened that the affirmative action case managed to make it up to the Supreme Court, but any one of these probably could have as well. So we were talking earlier, and so before we even get into the arguments, give us an example of one of the examples maybe in your article of a company that's finding themselves in sort of the crosshairs of these conservative groups, but also pressure to remain diverse and inclusive.
Sure. So one example we wrote about was Comcast, cable giant, which was sued for starting a small business grant program in the wake of the pandemic or soon after the pandemic began. And they were offering small grants and particularly offering these to companies that were at least majority owned by a person of color or a woman. And that program was challenged by a group of conservative legal activists. The case settled, and the following year after it was begun, Comcast opened that program to any small business.
So the affirmative action decision by the Supreme Court has emboldened this push by conservative activists to now challenge this diversity, equity, inclusion program. Fair to say?
Yes.
There was another program you mentioned in your article down in Texas. I believe it was a white woman trying to start a company as it related to delivery company with Amazon. Tell us about that one.
Sure. So Amazon had a program where they were offering some startup funds to independent delivery services that were going to come to work for them. Some startup funds were available particularly to delivery companies started by people of color. Again, the theory being that there are barriers to inclusion by particular groups. We want to help overcome those barriers, open up the opportunity to as many people as possible. A white woman backed by some conservative legal groups challenged this and said she was being excluded from the program. Amazon has moved to dismiss the case. They have said this is we never excluded anyone from becoming a delivery contractor for us, and basically said, they're going to go forward with
Also, she had never actually signed up for the program, but she was part of the lot. That was part of it. So those are a couple of examples. The irony of this is some of the arguments that are being used to dismantle these efforts are these very same arguments that people put in place to combat racism. Right. Tell me about the arguments that the conservative groups are using, but also why it was that the affirmative action case at the Supreme Court fueled this.
So, the affirmative action case, as you mentioned, it addressed higher education. It did not address any of these employment programs. Right. But that may be the next frontier, and I think that's partly what these groups are counting on. But the Civil Rights Act of 1964, Title VII, is what governs workplace decisions, and so it says you cannot discriminate. You cannot have preferences based on race, sex, national origin, religion. So that's one statute that's often cited. There's also, very interestingly, a Civil Rights Act of 1866.
And they're arguing that some of these programs discriminate against.
Yes, that they have unfair preferences.
Right.
There's also a Civil Rights Act of 1866, which was passed right after the Civil War, designed to extend opportunities to former slaves. And that is also being called on to say, well, you can't have racial preferences in contracting decisions. So you see these same tools that were used to expand opportunity now being used to challenge these DEI programs.
Escalating fight over diversity in business. It involves the Fearless Fund, which is the first venture capital fund built by women of color for women of color. According to the fund, just 0.39% of venture capital funding goes to businesses started by women of color. The Fearless Fund was founded in 2019 to help close that gap by providing funding and support to Black female founders.
But now it's facing a lawsuit by the American Alliance for Equal Rights. That's a group founded by the conservative activist who was behind the effort to end affirmative action in college admissions. Now, this suit alleges that the fund's Fearless Strivers Grant Contest is, quote, their words, a racially discriminatory program that blatantly violates the Civil Rights Act's guarantee of race neutrality because its $20,000 grant prizes are only open to Black women. We are joined now by Fearless Fund co-founder and CEO. Her name is Ariane Simone. This is her first interview since the lawsuit was filed against her company. Good morning to you, Ariane Simone. Good to have you here at the table.
Good morning. Thank you for having me.
So what was your first thought when you heard that you and your partners were being sued?
My initial thought, I didn't think that this was real, but once I realized that it was, I was aware that it was definitely an attack to dismantle and address our economic freedom as people of color. But I knew the moment it happened that we would continue to do the amazing work that we do.
You didn't think it was real. What did you think it was? What did you think?
When the emails came through, I honestly thought it was ChatGPT.
You did?
Yeah.
You thought maybe you were being punked somehow.
Yes.
So now that you know that it is real, what's your response? What are you all planning to do?
Oh, our response is simple. We plan to continue to do the work that we do for women of color. As you stated before, women of color are the most founded entrepreneurial demographic. They are just the least funded.
Why do you think that is? I mean, when I read the number, Ariane, I thought I was reading it wrong because the number was so low. Less than 1%.
Yes, fraction of a percent.
Yes.
I think even beyond racism and sexism, there is something called proximity. The investors in the venture capital field, 92% of them are white male. I'm a strong believer that if we can diversify the investors, we can diversify the investments.
Now, we mentioned that number, 0.39%, and some may listen and say, well, that's something. But according to the fund in 2022, capital firms deployed $288 billion. So that fraction of 1%, it doesn't make sense when it comes to black women being funded. I never really understood how someone who had a head start in the race would look at those behind them and try to trip them up. What is your message to those that are looking to trip you up?
Oh, our message is clear. Our corporate partners stand by us. MasterCard, Bank of America, Ally Bank, JP Morgan Chase, and many others.
What have you heard from them?
Oh, we've been in touch with all of our investors. They stand by their DEI programs. They stand by their commitments that they've made post-George Floyd to the black community. They are in agreement with the work that they have done and the work they are doing with us.
Black people are under attack in America, but we are not victims and we are not powerless. Our fundamental rights are under assault and our very history is being denied, but we will not stand by quietly as it happens.
The goal is to condition this generation to white supremacy because they see this generation is pushing against this far right-wing fascist ideology. We want our freedoms. We want our people to be safe. And so seeing that as an existential threat to the Republican Party, they aim to change the way a generation thinks by changing what we teach them.
Members of the Congressional Black Caucus did not hold back at a press conference on the state of race in America earlier this week on Capitol Hill. The group highlighted a slew of right-wing attacks on blackness and civil rights, like the ideologically driven Supreme Court ruling that put an end to affirmative action, the challenges to voting rights and equitable redistricting seen recently in states such as Alabama and Louisiana, the onslaught of book bans and revisionist curriculum standards for teaching black history, and the lack of action to address the black maternal mortality crisis in a post-Roe v. Wade landscape. In the words of Congresswoman Terry Sewell of Alabama, old battles have indeed become new again. Joining me now is the chair of the Congressional Black Caucus, Congressman Steve Horsford of Nevada, and NYU history professor and author of Strong Men, Mussolini to the Present, Ruth Ben-Ghiat. Thank you both very much for coming to the Sunday show. This is an interesting pairing, but the conversation we are about to have is going to merge what each of you has been talking about separately on our air for months now. And Congressman, let me start with you. How dangerous of a moment in time is this for Black Americans?
Well, thank you for having me on, Jonathan. I'm here in Boston at the NAACP National Convention, meeting with President Johnson and leaders across the country, along with our members of the Congressional Black Caucus. And in fact, we did a Democracy for the People event just yesterday, talking to constituents here in Boston in Congresswoman Presley's district. And what we hear all across the country as part of our summer of action is Black people literally feel attacked. There's a ban on black, a ban on blackness happening. It's targeted, it's well-funded, it's organized, and it's orchestrated. And what we are saying as the Congressional Black Caucus is that we're not going back. We're not going to be silenced. We're going to call out those who are promoting this division in our country, from the Supreme Court to state legislatures who are attacking our fundamental rights and eroding our freedoms, whether that's on women's reproductive justice, whether that's on access to college, whether it's protecting our most fundamental right, which is our right to vote. We have fought too hard for these freedoms, and we're not going back.
Mm-hmm. And Congressman, we have heard some controversial race-related comments from some Republicans. Congressman Eli Crane, Republican of Arizona, referred to black people as, quote, colored people on the House floor, and then claimed he misspoke. Meanwhile, Senator Tommy Tuberville, Republican of Alabama, asserted a few times and then backtracked a few times that white nationalists are not racist. Why is it important to call this out?
Well, Jonathan, when these individuals use racist tropes, terms that have very negative, derogatory history and meaning, whether it's the term colored people on the House floor in 2023 or Senator Tuberville saying that white nationalists are not racist. If they're not racist, then what are they? And every time I think they use the word woke, I want to ask them, who are you talking about? Is it black people? Is it other people of color? Is it the LGBTQ community? Is it women? Because all of these attacks, whether it's on women's access to health care, whether it is providing for fair and free maps, how is it that the state legislature in Alabama can defy the Supreme Court, who told them you have to have two opportunity districts, which essentially means that black people deserve to have equal representation. And in Alabama and in Louisiana, they are now defying the Supreme Court. This is a ban on blackness, and the Congressional Black Caucus won't stand for it.
And Ruth, more to the point, the CBC took aim at Governor Ron DeSantis and his efforts to de-emphasize race in his state's public school curriculum. And you also see school districts like the one in Houston, Texas, who are eliminating libraries, and in that specific case, converting them to discipline centers. How do attacks on information, books, and libraries play into the authoritarian playbook you talk so often about?
Yeah, I want to talk. It's how the pieces fit together, and so there's a war on blackness at the ballot box, disenfranchising blacks. There's a war actually on blacks at their places of employment through the suppression of diversity and inclusion initiatives. And there's the war on blackness and education. And all of these things fit together. And whenever I hear, about DeSantis or others' anti-wokeness, I think of a line I have in my book from somebody who lived under the dictatorship in Chile. And he says, dictatorships want people to go to sleep. And so, all of the education initiatives of the GOP, they mirror the disenfranchisement of black people at the ballot box by not only erasing major parts of their history, but rewriting history in ways that satisfy, white people. So it's an extension, and it's the way these things fit together. There's an overall plan which stands out to me as somebody who studies the GOP as an autocratic party.
Mm-hmm. And Donald Trump, running for president, has two criminal indictments against him, and yet each time an indictment is announced against him, his poll numbers go up. And on the campaign trail, as he has been doing this week, he'll go out there and tell his crowd, like he did last night at a rally, "I'm being indicted for you." This is standard for him on the campaign trail and standard for dictators, no?
Yeah, because, he has to be the victim. And by extension, what he's done now is the more hot water he's in, the more he knows that maybe some people eventually think he has too much baggage. So what you really want is to get people feeling there's an existential threat against them. And so he's being indicted for them. He just stands in the way because they're the real targets. And if we relate this to the questions of race and education, it's creating an educational and emotional environment so whites feel that they're under attack all the time, and criminalizing black people and non-whites in general, non-Christian whites, is part of this game to keep people in a state of tension. And, the Prager curriculum that Ron DeSantis is adopting, which is not accredited, by the way, it's a propaganda outfit. And all of these GOP, education measures, they all have the same language, that they want to remove emotional distress, like sources, things that make white people feel guilty. And so they can feel like, victims. And so Trump playing on white victimhood, this has been one of his strongest cards.
The Supreme Court struck down President Biden's student loan forgiveness program, which was set to wipe out nearly $430 billion in debt. The 6-3 decision signals to millions of borrowers that they must begin paying back their debt after a 3-year pause as a result of the pandemic.
For borrowers around the country who had been making financial decisions based on the hope that they would see this forgiveness, it could have major implications to their pocketbooks.
Biden's student loan forgiveness plan, which was announced last August, sought to permanently forgive up to $20,000 in federal student debt for millions of Americans.
95% of the borrowers can benefit from these actions. That's 43 million people.
More than 26 million people applied for the program or were automatically eligible. And of those 26 million, more than 16 million were approved for loan cancellation by the Education Department. The plan would cost the federal government more than $400 billion.
The question is really whether the president has the authority himself to wipe away potentially hundreds of billions of dollars in student loan debt, or whether Congress needed to give explicit authority to the president to do that.
Chief Justice John Roberts said in the opinion that while the Education Secretary, a member of President Biden's cabinet, has the authority to waive or modify existing statutory or regulatory provisions applicable to financial assistance programs under the Education Act, he is not allowed to rewrite that statute from the ground up. Writing in dissent for the court's 3 liberals, Justice Elena Kagan accused the majority of exceeding the court's proper limited role in our nation's governance. Before Biden's forgiveness proposal, borrowers were already receiving debt relief after President Trump announced a suspension on payments due to the COVID-19 pandemic. Nearly 3 years later, those who were hoping to see at least some of their loans forgiven will have to restart their payments.
Not only are they going to have to resume payments for the first time in 3 years, but they're also going to have to potentially pay on a larger balance than they might have expected before.
Once resumed, the typical student loan payment will be between $210 and $314 a month, according to a Wells Fargo report. And those payments come at a time when borrowers are facing higher prices and inflation.
People have gotten used to not having to make these payments, and they've used that money for other things. That money is now going to need to be put towards something different. And so that could really change the way that households dole out their payments every month.
The share of households with student loan debt has more than doubled from 1989 to 2019, with 30% of Black households, 20% of white households, and 14% of Hispanic households holding debt in 2019.
If you're paying back student loans through this, they call it income-based repayment, my plan is to cut your payments in half.
On the 2020 campaign trail, Biden promised that he would erase or significantly reduce student loan debt. And he campaigned on his executive action again before last year's midterm elections.
We're following through on a promise I gave to millions of Americans with student loans, just a little more breathing room.
So as we enter the 2024 election season, it will be notable to see who voters blame for this outcome. Do they blame Republicans and conservative majority Supreme Court for striking it down? Or do they blame President Biden for maybe getting out ahead of his skis and putting forward a proposal that would eventually be struck down in the court?
Publicly, the Biden administration projected confidence about the legality of their student loan forgiveness plan.
We are confident in our legal authority to carry out this program, and we won't let these baseless lawsuits stop us either.
But in private, they've been preparing for this very outcome. They've considered a bunch of different potential policies in response. The main one would allow borrowers with lower incomes to pay a smaller amount on the balance of their loans over time, and then eventually have the rest of their payment either reduced or forgiven. And separately, they've discussed also putting a temporary ban on penalties for people who aren't able to pay their loans. That would essentially prevent the federal government from recommending that people go into delinquency for not paying their loans. It's essentially like a small reprieve to help people get back into the swing of paying.
Let me begin by saying I know there are millions of Americans in this country who feel disappointed and discouraged or even a little bit angry about the court's decision today on student debt. And I must admit I do too. Before I tell you the steps we're going to take and want to talk about what we've been able to achieve so far on student loan over the past few years. First, we made the largest increase in Pell Grants in over a decade, helping students from families who nearly all make less than $60,000 a year. Then we fixed the so-called, with the help of the department, public service loan forgiveness program. So the borrowers who got into public service, such as school teachers, police officers, social workers, service members, they actually got the debt relief they were entitled to under the law. Before I came to office, only 7,000 people have benefited from that program. Today, over 600,000 borrowers have received relief from that program. And it's still available. So many more people can be helped. And I encourage you to apply if you haven't already. You're still eligible. Go to studentaid.gov. It matters. Third, my administration improved the program from the Obama-Biden administration on income-driven repayment plan. That's what it was referred to as. Back then, we set a limit. Student borrowers would pay no more than 10% of their disposable income to pay back their debt in any one time. My administration is going to reduce that to 5%. It's now the most generous repayment program ever. No one with an undergraduate loan today or in the future, whether from a community college or a four-year college, will have to pay more than 5% of their disposable income to repay their loan. And that's income after you pay for the necessities like housing and food and the like. Typical borrower is going to save about $1,000 a year. And if you keep up payments for 20 years without missing them, your total debt is forgiven after 20 years. That's what the program was before, but we've just reduced it to 5%. In addition to that, last year I announced my student debt relief plan, a plan that was on the verge of providing more than 40 million Americans with real debt relief, up to $10,000 for many borrowers and up to $20,000 for those who had gotten a Pell Grant. Nearly 90% of the relief would have gone to borrowers, 90% of it, making less than $75,000 a year. And no one making over $125,000 a year would qualify. This program was all set to begin. The website had been set up, the applications had been simplified so that it took less than 5 minutes to complete. Notice had been sent out to people about the relief they were eligible for. 16 million people had already been approved. The money was literally about to go out the door. And then Republican elected officials and special interests stepped in. They said, no, literally snatching from the hands of millions of Americans thousands of dollars in student debt relief that was about to change their lives. You know, these Republican officials just couldn't bear the thought of providing relief for working class, middle class Americans. Republican state officials sued my administration, attempting to block relief, including millions of their own constituents. Republicans in Congress voted to overturn the plan. I think every one. I don't think I had any Republican votes for this plan. At the same time, think about this. We all supported the Paycheck Protection Program. Remember PPP? You know, which was designed to help business owners who lost money because of the pandemic. It was a worthy program. But let's be clear. Some of the same elected Republicans, members of Congress who strongly opposed giving relief to students, got hundreds of thousands of dollars themselves in relief, members of Congress, because of the businesses they were able to keep open. Several members of Congress got over $1 million. All those loans were forgiven. You know how much that program cost? $760 billion. My program's too expensive. $360 billion more than I proposed in my student debt relief program. I was trying to provide students with $10,000 to $20,000 in relief. By comparison, the average amount forgiven in the PPP, the pandemic loan program, average amount forgiven was $70,000. Now, a kid making $60,000, trying to pay back his bills, asking for $10,000 in relief. Come on, the hypocrisy is stunning. You can't help a family making 75 grand a year, but you can help a millionaire and you have your debt forgiven. My plan would not only have been life-changing for millions of Americans, it would have been good for the American economy, freeing millions of Americans with a crushing burden of student debt. More homes would have been bought, more businesses would have been started, more couples would have had the confidence to start a family. Millions of people would have felt they could get on with their lives. These Republicans blocked all that. Now, in addition to the hypocrisy, some of these Republicans in Congress are shamelessly pushing to advance a bill in the coming weeks that gives hundreds of billions of dollars in tax breaks and handouts to the wealthiest Americans. They still haven't given up on making permanent a $2 trillion tax cut that they never paid for. Never paid for. $2 trillion. So let me be clear. Republicans in Congress, it's not about reducing the deficit. It's not about fairness and forgiving loans. It's only about forgiving loans they have to pay. Today, the Supreme Court sided with them. I believe the court's decision to strike down my student debt relief program was a mistake, was wrong. I'm not going to stop fighting to deliver borrowers what they need, particularly those at the bottom end of the economic scale. So we need to find a new way. And we're moving as fast as we can.
Today, we'll be discussing the Supreme Court confirmation hearing of Clarence Thomas, who was selected by George H.W. Bush to replace the legendary Thurgood Marshall on the court. In 1991, during his confirmation hearing to become an Associate Justice to the Supreme Court, Thomas faced accusations of sexual harassment from Anita Hill, who he had previously worked with. Thomas denied the allegations, and before the Senate Judiciary Committee, he went on to describe the treatment he was receiving from the Democrats and the media as a, quote, high-tech lynching. Lynching has never been something to allude to lightly. Invoking the term means invoking the long, traumatic, painful history that Black people have long had to endure. So by describing what was happening as a lynching, Thomas tapped into something deeply rooted and deeply controversial. Some thought Thomas was right to use the term, given the way that allegations of sexual misconduct have been used, often unjustly, against Black men. Others, however, thought that Thomas was manipulating Americans by disingenuously comparing what was happening to him to Black men who had been shot, drowned, or hanged from trees. There were many people who believed Anita Hill's allegations, and there were many people who did not. Hill's decision to come forward had ramifications beyond the confirmation hearing. Following the tense confirmation battle, many companies, organizations, and institutions began taking a deeper look at their own sexual harassment policies and procedures. In the process, and throughout the rest of her life, Hill became a leader in the fight for workplace protections for all people. During the hearings and afterwards, many Black women remained strong supporters of Hill, both privately and publicly. After the hearings, in which Thomas was narrowly confirmed by a 52-48 vote in the Senate on October 15, 1991, the National Coalition of 100 Black Women awarded Hill the Ida B. Wells Award in honor of her courage in coming forward. Additionally, in an ad published in the New York Times, 1,603 African-American women defended Hill. In the ad, titled African-American Women in Defense of Ourselves, the women wrote, quote, "We are particularly outraged by the racist and sexist treatment of Professor Anita Hill, an African-American woman who was maligned and castigated for daring to speak publicly of her own experience of sexual abuse. The malicious defamation of Professor Hill insulted all women of African descent and sent a dangerous message to any woman who might contemplate a sexual harassment complaint." The women were responding not only to the public treatment of Hill, but also because of their concern that Hill's treatment might dissuade other Black women from coming forward with their experience of sexual harassment in the workplace. The group also engaged in criticism of Thomas beyond the allegations of harassment and let it be known that racial representation on the court was not sufficient if the justice was going to, as they believed Thomas would, fail to protect the rights of the vast majority of Black Americans. Another part of the ad read, quote, "As women of African descent, we are deeply troubled by the recent nomination, confirmation, and seating of Clarence Thomas as an Associate Justice of the U.S. Supreme Court. We know that the presence of Clarence Thomas on the court will be continually used to divert attention from historic struggles for social justice through suggestions that the presence of a Black man on the Supreme Court constitutes as an assurance that the rights of African Americans will be protected." And they weren't alone in their concern. The NAACP, the National Organization for Women, and dozens more were all concerned that Thomas would vote in ways that were the opposite of Thurgood Marshall, in ways that would be a threat to important issues like affirmative action and abortion. In the aftermath of the case, Anita Hill continued to be a law professor and also went on to become a prominent social activist, public speaker, and advocate for women's rights. The case experienced renewed interest and attention when, in 2018, during the hearing of Supreme Court Justice nominee Brett Kavanaugh, Christine Blasey Ford brought allegations of sexual assault against him. Many parallels were drawn between the two cases, not the least of which because they both caused divisions along political and gender lines throughout the United States. Although there were marked similarities between the two sets of allegations, it's worth mentioning that, in large part because of the Me Too movement, which was started by a Black woman named Tarana Burke, there's a difference in public awareness of and sensitivity to issues of sexual harassment today compared to when Hill came forward in 1991. The real legacy of the Anita Hill and Clarence Thomas case is that it inspired future generations of women, particularly Black women, to speak up in defense of themselves and their right to safety from harassment in the workplace. In 2021, Hill herself said, quote, 30 years later, I'm here to say that even though Clarence Thomas was confirmed, I do believe that what I did was effective because it opened up the conversation publicly in a way that had never been done before. I've heard from people whose lives have been changed because that conversation was open. Even with that being true, for Hill, it didn't come without a cost. After the hearing, Hill faced public scrutiny and attempts to discredit her and destroy her career. She received human feces through the mail and even death threats. But over time, she's been hailed as a change maker in conversations around women's safety in the workplace. Today, the legacy of this fight continues to give support and strength to all people who come forward with sexual harassment allegations and to create a safer, fairer, and more equitable workplace across the country for everyone.
Good evening from New York. I'm Chris Hayes. Today, in a landmark ruling that overturns decades of precedent, sweeps aside generations of arguments about racial justice and inequality, the Supreme Court, in a 6-3 decision, 6 conservatives to the 3 liberals, effectively got rid of the use of race in college admissions at all, even for the purposes of increasing diversity. In the wake of the decisions, many colleges and universities immediately sent letters to students and alumni outlining how they're going to operate going forward. One such school was the College of the Holy Cross in Massachusetts, which is notable because that is the alma mater of Justice Clarence Thomas, whose decades-long project to destroy affirmative action culminated in a victory today. Now, Thomas did not write the court's majority opinion. That was written by Justice Roberts. But he did write a fiery 58-page concurrence denouncing race as a factor in admissions as policies that, and I quote him here, fly in the face of our colorblind Constitution and our nation's equality ideal. Clarence Thomas did not always think this way. In the late 1960s, when he was at Holy Cross, he was one of just a few dozen black students at that college. As Joel Anderson writes for Slate, quote, he got admitted thanks to his good grades and a recommendation from a nun, and maybe in part because the school was actively looking for black students. It was the 1960s. It was in the wake of the Watts riots. The school had not had many black students, and it went out looking for some. And once he got to Holy Cross, well, Thomas's politics there were downright radical.
He definitely was inspired by the Black Panthers. He dressed like them. He talked like them. He had a beret, he had army fatigues, and he had the army boots.
He wore an afro. He was out there with everyone else.
After completing his undergraduate degree, Thomas was accepted at a number of prestigious law schools, including Harvard, but he chose to attend Yale Law because he believed the campus's liberal politics best aligned with his own. While there, however, Thomas became disillusioned with his own status at that elite university. As the New York Times reported back in 1991, Thomas was accepted to Yale as part of the school's explicit affirmative action plan to admit more students of color. But he resented any suggestion that he received any special consideration because of his race. And once he graduated from Yale Law, Thomas blamed his initial inability to find work in the legal profession, not on the fact that many legal institutions and law firms in the 1970s were still redoubts of racism and white supremacy and had racist hiring practices and did not want to hire him, but rather on the belief that his degree had been tainted by the implication of affirmative action.
He had his Yale law degree and he had a 10-cent stamp stuck to it. You know, like a 10-cent price tag stuck to it. Because he's like, yeah, this is what it's worth, right? 10 cents, right? No more.
He came to blame affirmative action for the rejection he felt.
Now I knew what a law degree from Yale was worth when it bore the taint of racial preference. I was humiliated and desperate.
Eventually, Thomas found a job in the office of the conservative Missouri Attorney General John Danforth, who recently told the Slow Burn podcast that he hired Thomas in part because of his race.
My ambition was that the AG's office was to be the best law office in the state. Now, did I also think that it was important to have a diverse office? Yes, I did. And did I think that it would be wonderful to hire Clarence Thomas for that reason? Yes. But the most important reason was I had to get the job done.
From there, Thomas' star continued to rise in conservative legal circles, a rise that, according to his ex-girlfriend, was again predicated in part on affirmative action.
In 1982, the White House offered Thomas a big promotion, the chance to run his own federal agency. The trouble was, that agency was the Equal Employment Opportunity Commission. This was exactly the kind of role Clarence Thomas didn't want, a position focused on race and discrimination.
He didn't want to be there. He was resentful that he had not been offered something that a white person would want.
Thomas was in a bind. He wanted to keep rising in the administration, but he didn't want to rise this way.
He didn't want anyone to think that he had gotten a job because he was black. Of course, every job he had ever gotten was because he was black.
Now, I want to be absolutely clear here. No one is saying that Clarence Thomas was unqualified for any of the long list of jobs. Even his critics, his harshest critics of his jurisprudence, can concede that he is undoubtedly one of the most, if not the most, important and influential legal minds of his generation. But that mistaken belief that race-based consideration, diversity-based consideration, and some elusive concept of true merit abstracted from that are mutually exclusive is the foundational lie on which today's Supreme Court decision was built. It was that belief, however, that helped secure Thomas's legal legacy. Thomas was eventually appointed to the D.C. Court of Appeals by President George H.W. Bush, and just 2 years later, Bush nominated him to the Supreme Court to replace the retiring Justice Thurgood Marshall, at that point the only black person to ever sit on the nation's highest court.
The president called Thomas the best qualified person for the job and denied that he selected Thomas to replace the retiring Thurgood Marshall because he's black.
And the fact he's minority, so much the better. But that is not the factor, and I would strongly resent any charge that might be forthcoming on quotas when it relates to appointing the best man to the court.
Again, same thing here. Thomas was both qualified for the position on the court, as were probably several dozen folks, maybe more. He was also nominated due to the obvious political motivations in replacing the nation's first black Justice Thurgood Marshall. During his confirmation hearings, Thomas was asked about his own vocal opposition to affirmative action.
The question is directly in entry to Yale. Were you part of an affirmative action quota? Were you part of a racial quota in terms of entering that law school?
Senator, I have not during my adult life or during my academic career been a part of any quota. The effort on the part of Yale during my years there was to reach out and open its doors to minorities whom it felt were qualified. And I took them at their word on that. And I have advocated that very kind of affirmative action.
Just think about that moment for a second, right? Now, having seen some of this man's trajectory in his bio, right? The thing he hates more than anything, that wounds his pride, that enrages him, is to be viewed as being less than or not qualified, as being an affirmative action case. And yet at every key juncture in his life, he is asked about it over and over again. And for Thomas and the conservative majority in the court, it all boils down again to this nebulous concept of merit, of qualified, who is deserving of opportunities and who's not. But I think that misses the point. It's really a question about what kinds of institutions and really what kind of society we want to have. Do we want a society in which people like Clarence Thomas, from the small town of Pinpoint, Georgia, just several generations removed from slavery and Jim Crow, are selected, nurtured, and encouraged? Or ones in which they don't go to Holy Cross and they don't go to Yale and they don't end up in the courts? And instead, those schools and those institutions pick more sailing team members and legacies. One of the things we saw today, and we saw a lot, we're going to talk about it, was a brilliant man who was able to overcome centuries of institutionalized prejudice, who was able to come from the most unlikely of backgrounds, with the help of a system designed to accomplish just that, turn around and pull the ladder up behind him.
The thing that needs to happen right now is for Thomas to have some dignity and resign. He is a Supreme Court justice who is able to tell for certain what you can do with your body and your uterus, whether Thomas, he pulls out the Ouija board, can tell whether or not Thomas Jefferson wanted you to have an AR-15, but he can't fill out a form.
Right.
He can't fill out a financial disclosure form.
It's too hard for him.
Justice Thomas ruled against a death row inmate who wanted to bring up evidence of his actual innocence. The defense attorney at the time didn't bring it up, and Thomas said that because the defense attorney didn't bring up the innocence at trial, that the inmate couldn't use it now. And so even though there was evidence of his actual innocence, that man is still sentenced to death row. That is the justice.
So he can't amend his.
Literally has a man right now set to die for not putting something in at an earlier date. That's the justice who now says, actually, I'll just amend my financial disclosure forms and it'll be fine.
Gene, your new column in the Washington Post is entitled Clarence Thomas's Explanations Fail the Laugh Test. This story is outrageous. In it, you write, quote, in 1969, Supreme Court Justice Abe Fortas resigned after it was learned he had accepted and then returned $20,000 from a Wall Street financier. Thomas accepted gifts from Crow worth many times that amount, even counting for inflation, and failed to report them. And then there is all the money Ginny Thomas has received from right-wing organizations that lobby on issues before the court, plus her outrageous involvement in the Stop the Steal putsch that led the January 6, 2021 Capitol insurrection. Thomas doesn't believe in affirmative action or protecting voting rights, though he benefited from both. He does believe in living the good life among millionaires and billionaires whose interests he just happens to protect in his opinions. My mental image of Thomas used to be of him sitting on the Supreme Court bench during arguments, silent and scowling. Now I see him on vacation, smoking a cigar with Crow and his buddies, laughing as though he doesn't have a care in the world. The joke is on us. So let's back up a little bit. This is a donor. Talk about who Mr. Crow is, and also why isn't there, I know that there may be an ethics investigation opened into this, but this seems like perhaps something that could, expose the justice to being completely impaired when it comes to being able to make objective decisions.
Well, look, so we're talking about gifts that Thomas accepted from Harlan Crow, who is a Texas billionaire. He's actually the son of Trammell Crow, who was once the biggest landlord in the country. It's a big real estate empire. And so Harlan Crow, who has a big collection of Hitler memorabilia, but let's not get into that. Harlan Crow gave Clarence Thomas and Ginny Thomas these lavish vacations, including a $500,000 trip to Indonesia one year. It would have cost $500,000 if they'd paid a dime. Trips on his private jet, on cruising around island to island on a super yacht, all expenses paid. Plus many other vacations. Yearly, they go to some resort he owns. Again,
and his mother's house.
Right. And it's incredible. And he never reported this. He never reported a penny of these donations. And then Harlan Crow bought his mother's house and fixed it up. As far as we can tell, it has let her live there rent-free. We're not sure of that. They haven't really commented on that, but I take their no comment as basically as confirmation. And again, so he expects us to take seriously his reading of the tiniest nuances of the Constitution and give them great weight. And he can't read a simple disclosure form. He can't see the difference between, hospitality, which may be allowed, and hundreds and hundreds of thousands of dollars in gifts, including private jet travel. It's absurd. It's ridiculous. And he's just laughing at us. And there are really no rules and certainly no punishments for ethics at the Supreme Court, and which is also outrageous. There's not a code really. There's a code that covers judges in general, and they kind of try to follow it, and they're supposed to follow it. They didn't follow it. So what? What can anybody do to him short of impeachment and removal? That could happen, but it's not going to happen. So here we are again. The joke is on us.
Gene, talk about that, the code, and why there isn't one. What's the historical reasoning for not having some form of accountability? Because there is forms of accountability for elected officials, of course. There are codes they're meant to follow. There are disclosures that they're meant to make, certainly when it comes to lavish vacations or having your mother's house renovated by somebody where there could be a potential conflict of interest. Why not the Supreme Court? And what might change because of these disclosures? I ask that realizing that not much might change, but let's ask it anyway.
Yeah, let's ask it anyway. Much should change, but I kind of doubt that much will change. I mean, the Supreme Court has the view of Congress and the president has always been that the Supreme Court basically gets to govern itself and set its own rules, and the Supreme Court never has set any sort of really binding rules on ethics, and it refuses to do so, and I don't think it will. And Chief Justice Roberts, he has not commented really on this. He can't love it. He can't love the scandal that the court has been dragged into by Justice Thomas, but there's very little he can do to him, really. I mean, what can he do? The Chief Justice is sort of first among equals, but each justice is kind of his own sovereign country almost at the court, and there's not much anybody can do. Now, you would think that the Supreme Court of the United States would care about having an ethics code, would care about being perceived as being, cleaner than Caesar's wife. But no, they simply don't. And I don't think that's going to change.
Indulge me for a moment in a thought experiment. What if Supreme Court Justice Ketanji Brown Jackson's husband was discovered to have been working with a major Democratic donor on the funding of left-wing political activism for several years, say with, right-wing villain and multi-billionaire George Soros? What would Fox do? What would the Republican Party do? They'd lose their mind. You would already have impeachment articles drawn up in the House against Justice Jackson, even though George Soros, contrary to what Republicans would like you to think, has actually done nothing wrong. Well, that is the subject of Politico's new reporting involving Supreme Court Justice Clarence Thomas, his wife Ginny, and the multimillionaire conservative judicial activist and lobbyist Leonard Leo. This comes on the back of the myriad Thomas scandals in recent memory, like when he failed to recuse himself from 2020 election-related cases, even though his wife Ginny Thomas has been accused of helping push the coup attempt in 2020. Then there was the ProPublica reporting this year, revealing how Thomas failed to disclose multiple trips on billionaire benefactor Harlan Crow's 162-foot yacht, flights on his private jet, and weeks at his private resort. Or the fact that Crow paid for his mother's house, where she still lives rent-free, or that he paid for his grandnephew's school tuition, who Thomas raised as his own son. That reporting forced him to amend his financial disclosure last month. And now a new Politico investigation is adding to that list, reporting that Ginny Thomas's web of ties to Leonard Leo is far deeper and more financially entangled than previously known.
United States is a nation obsessed with achievement, or perhaps more accurately, we're obsessed with superiority. Being the best at something is one of the few things Americans consider truly admirable, along with making money. And if you're the best at making money, well, the average American will worship you like some kind of god of the free market. Most people think this is normal and healthy because we live in a meritocracy, a place where talent and effort determine who succeeds and who does not. A totally fair and egalitarian way of structuring society. Those who work hard and have some natural intelligence are rewarded, and those who don't just sort of fade away. It's natural. There are a couple of problems here. One of them being that the US is not actually a meritocracy, and the other that meritocracy is not something we should strive for. In this episode, we're going to examine what it means to live in a meritocracy and consider the dark side of such a system. Have you ever played Monopoly? It's a quintessentially American board game. The players make their way around the board, buying up property and trying to extract money from the other players until one person reigns supreme and everyone else is trapped in a vicious cycle of poverty. As a fun side note, Monopoly was actually created as a critique of the capitalist system. But of course it's lost that meaning over the years, to the point where now we print a Miss Monopoly variant so we make sure little girls grow up learning that they too can exploit their fellow human beings. Now, imagine you're playing a game of Monopoly, except this time, another player is randomly given a huge starting bonus. They start the game with twice as much money, they collect twice as much when passing go, and they get to roll 2 dice instead of 1. You'd probably be pretty upset at this clear unfairness. About a decade ago, this type of rigged game was used as a study to determine the effect of wealth on compassion and empathy. 200 students played rigged games of Monopoly, and the findings were striking. Without fail, the rich player quickly became cocky and aggressive. They began to physically take up more space at the table, spreading out their pieces over a larger area. They moved their pieces with greater force, and they even consumed more of the snacks left out by the study facilitators. But what's most interesting, and most telling about the effects of this sort of head start wealth, are their responses to the question of how they won the game. The rich players were more than twice as likely as the poor players to talk about game strategy, and claim that they had earned their win. The real answer, of course, is that they had an unfair advantage and were set up to succeed from the very beginning. Now imagine that this advantage was not as obvious as being handed twice as much play money as the other guy 2 hours ago, but rather a complex series of privileges afforded to you over your entire life. How do you think these same participants would view their achievements then? The results of the Monopoly study correspond with established findings on the effects of generational wealth and privilege. Successful people have a tendency to feel like they've earned their success, like they deserve it. And, as a natural consequence, they tend to believe that less successful people deserve their lot. The wealthy justify their success by their supposed good choices, intelligence, and pragmatic actions, their merit. And often that does play a role. But the connection between this mindset and relative privilege is well established and should not be overlooked. Now, what does this have to do with the idea of meritocracy? Well, the common claim is that the US functions like a normal game of Monopoly. Everyone starts on equal footing, and it's only through cleverness and hard work that anyone comes out ahead. Everyone has the same opportunities, and it's up to them to make use of them. On the surface, this may sound like a good idea, but it has some real problems. First of all, it should be obvious that modern capitalism is nothing like a fair game of Monopoly. In fact, it's much worse than even the rigged game from the study. A group of researchers have put together a map called the Opportunity Atlas, which can accurately predict the future income of people from any given zip code based on their socioeconomic background. As much as we may want to ignore it, we can no longer deny the concrete link between family status, wealth, location, background, and rates of future financial success. There's a certain type of person who will pick up their copy of the bell curve and say, look, some types of people are just inherently smarter and they tend to live in the same area. First of all, these people should be aware by now that they're willingly consuming debunked racial pseudoscience. But something tells me they've made up their minds on the subject. Fine, let's take another data point. Children adopted at a young age from less than optimistic conditions and placed in a home with access to more opportunities will inevitably lead a more financially successful life than their counterparts who stayed in precarious situations. By now, it should be obvious that we do not live in a meritocracy. What we need to realize next is that we should not want to live in one. If the idea sounds nice at first, it's only because we've been so conditioned by capitalism that we assume there must naturally be those who succeed and those who fail. Despite our best intentions, for many people there's still a nagging feeling that those who are financially successful earned their money by working hard and making moral and upright choices, and those who are poor and suffering are somehow at fault and morally deficient. This is despite the fact that we now know conclusively that socioeconomic background is the prime determinant of future success. We know that there is no inherent difference in intelligence of young children, and we know that the wealthy would not have their wealth without the exploitation of others. It's a hard mindset to overcome, even with the mountains of evidence at our disposal. But thankfully, it appears that many young people are beginning to come around. As financial opportunities dry up even for those from affluent backgrounds, it's becoming more apparent that American meritocracy is a myth. And even if it weren't, a meritocracy is no way to structure a modern society. Instead of encouraging winners and losers, why not structure society in such a way that everyone is afforded a decent quality of life, where life itself is not seen as a competition, but a collaboration, each contributing however they're able, and everyone benefiting from societal advances. Meritocracy may have been a nice idea during feudal times, but there's no need for it today. It's ridiculous that the modern aristocracy is able to perpetuate generational wealth by hoarding the nation's opportunities, while millions of equally capable American children are left hanging by a thread, dangling over a pit of precarity from which there is little chance of escape. Let's leave the notion of meritocracy behind and work together to build a more equitable society, one that works for everyone, not just the wealthy and well-connected.
I wanted to write about what it means that some people seemingly have to earn or have to do something to deserve access to things that we think about as basic necessities. So how hard can you work to earn access to a meal every night, or or what do you have to do to deserve a good education? What do you have to do to deserve to have housing? And that's one of the ways that race sort of works in this country, is that there's some people that are deemed inherently worthy. So we think about the way whiteness works and white supremacy. White people are just deemed worthy of things. But there's this notion that you need to work extra hard to deserve a great public education. I am from Baltimore, and we think about the school system in Baltimore City is not funded equitably at all. And it's like, well, what do those kids have to do to earn equitable funding? They actually don't need to do anything besides just be alive. And one of the things that we need to do is make sure that we set up a system where people just have the basic necessities like food, water, education. We can guarantee that. There's no reason why we don't have it. Yeah, so I actually think about the difference between equality and equity, right? The equality is everybody gets the same thing. Equity is that people get what they need and deserve. And in the work of justice, we are almost always fighting for equity. So we think about things like school funding. We are not asking for equal funding. We know that it just costs more to educate kids who grow up in poverty. It costs more to educate kids with special needs. And we know that we need to pay that cost, that those kids deserve that. We're not saying that every kid, it costs the same to educate every kid. That's just not true. We want a world of equity where people get what they need and deserve. We know the disparities around criminal justice, that there are disparities around race, and we want an equitable system that doesn't penalize people for where they live, how they show up, what zip code they come from. So the difference between equity and equality is an important distinction, and the only way to get to equality access, whatever metric of equality you want, is by having equity of resources, right? Equity of experiences, that the equity piece says that you need something different and you deserve something different, and from a system level, I'm gonna make sure that you have access to that. So I was talking to somebody about food stamps once, and she was like, people should have to work for food stamps because if they work for it, they'll have dignity. And I'm like, not eating, I think, is pretty undignified. Like, not having food is a lack of dignity right there, right? That food is one of those basic things. We have enough food that we can feed everybody. We have enough water that everybody can, have a meal. 3 meals every single day. We can guarantee those things. We don't need to artificially create this requirement that people work so they can earn food. We can actually guarantee these basic things for people. And one of the things that we have to do as we fight for social justice is talk about these things as basic as they are. That it's not radical to believe that we can live in a world where the police don't kill people. It's not radical to say that every kid should be able to read and write. It's not radical or extreme to say that we can feed every single person every single day. That the only radical thing about it is that we have to say it in the first place. Like that is actually where the radical part comes in. And I think about that because polarization thrives in a world of extremes. And so often people want to paint our positions as extreme. It's not an extreme position to say like that there should be equity and fairness. That's not extreme. The only extreme thing about it is that we don't have it right now and that we have to fight for it.
Here's a question we should all be asking. What went wrong? Not just with the pandemic, but with our civic life. What brought us to this polarized, rancorous political moment? In recent decades, the divide between winners and losers has been deepening, poisoning our politics, setting us apart. This divide is partly about inequality, but it's also about the attitudes toward winning and losing that have come with it. Those who landed on top came to believe that their success was their own doing, a measure of their merit, and that those who lost out had no one to blame but themselves. This way of thinking about success arises from a seemingly attractive principle. If everyone has an equal chance, the winners deserve their winnings. This is the heart of the meritocratic ideal. In practice, of course, we fall far short. Not everybody has an equal chance to rise. Children born to poor families tend to stay poor when they grow up. Affluent parents are able to pass their advantages on to their kids. At Ivy League universities, for example, there are more students from the top 1% than from the entire bottom half of the country combined. But the problem isn't only that we failed to live up to the meritocratic principles we proclaim. The ideal itself is flawed. It has a dark side. Meritocracy is corrosive of the common good. It leads to hubris among the winners and humiliation among those who lose out. It encourages the successful to inhale too deeply of their success, to forget the luck and good fortune that helped them on their way. And it leads them to look down on those less fortunate, less credentialed than themselves. This matters for politics. One of the most potent sources of the populist backlash is the sense among many working people that elites look down on them. It's a legitimate complaint. Even as globalization brought deepening inequality and stagnant wages, its proponents offered workers some bracing advice. If you want to compete and win in the global economy, go to college. What you earn depends on what you learn. You can make it if you try. These elites missed the insult implicit in this advice. If you don't go to college, if you don't flourish in the new economy, your failure is your fault. That's the implication. It's no wonder many working people turned against meritocratic elites. So what should we do? We need to rethink three aspects of our civic life: the role of college, the dignity of work, and the meaning of success. We should begin by rethinking the role of universities as arbiters of opportunity. For those of us who spend our days in the company of the credentialed, it's easy to forget a simple fact. Most people don't have a four-year college degree. In fact, nearly 2/3 of Americans don't. So it is folly to create an economy that makes a university diploma a necessary condition of dignified work and a decent life. Encouraging people to go to college is a good thing. Broadening access for those who can't afford it is even better. But this is not a solution to inequality. We should focus less on arming people for meritocratic combat and focus more on making life better for people who lack a diploma but who make essential contributions to our society. We should renew the dignity of work and place it at the center of our politics. We should remember that work is not only about making a living, it's also about contributing to the common good and winning recognition for doing so. Robert F. Kennedy put it well half a century ago. Fellowship, community, shared patriotism. These essential values do not come from just buying and consuming goods together. They come from dignified employment at decent pay, the kind of employment that enables us to say, I helped to build this country. I am a participant in its great public ventures. This civic sentiment is largely missing from our public life today. We often assume that the money people make is the measure of their contribution to the common good. But this is a mistake. Martin Luther King Jr. explained why. Reflecting on a strike by sanitation workers in Memphis, Tennessee, shortly before he was assassinated, King said, "The person who picks up our garbage is, in the final analysis, as significant as the physician. For if he doesn't do his job, diseases are rampant. All labor has dignity." Today's pandemic makes this clear. It reveals how deeply we rely on workers we often overlook. Delivery workers, maintenance workers, grocery store clerks, warehouse workers, truckers, nurse assistants, childcare workers, home health care providers. These are not the best paid or most honored workers. But now we see them as essential workers. This is a moment for a public debate about how to bring their pay and recognition into better alignment with the importance of their work. It is also time for a moral, even spiritual turning, questioning our meritocratic hubris. Do I morally deserve the talents that enable me to flourish? Is it my doing that I live in a society that prizes the talents I happen to have? Or is that my good luck? Insisting that my success is my due makes it hard to see myself in other people's shoes. Appreciating the role of luck in life can prompt a certain humility. There, but for the accident of birth, or the grace of God, or the mystery of fate, go I. This spirit of humility is the civic virtue we need now. It's the beginning of a way back from the harsh ethic of success that drives us apart. It points us beyond the tyranny of merit to a less rancorous, more generous public life.